I'm glad you're watching this presentation. This is one of our first videos that we're producing with easyelderlaw.com. It's covering the 2023 financial eligibility criteria for Medicaid. It's copywritten by easyelderlaw.com. Now, the terms of use are what are on the page and also what are on Easy Elder Law's terms of use page. Essentially, this is information. It is not legal advice. We're not making any attempt whatsoever to address your individual circumstances and provide answers that would relate to what's going on in your life or with your property. This is general information. And as Abraham Lincoln allegedly said, a man who is his own lawyer has a fool for a client. Now, when we're talking about Medicaid eligibility, the basic eligibility requirements include categorical eligibility, medical eligibility, and financial eligibility. The one we're focusing on here is financial eligibility, but don't forget that you must be aged, blind, or disabled. You must fit within a class of assistance, which includes the length of stay and level of care requirements. Medicaid does not help everyone. Medicaid helps people who fit within a class of assistance. And so primarily here we're talking about long-term care Medicaid in Georgia, and that would be income eligibility and resource eligibility. And we're going to focus beginning with how we would conduct, or how I would conduct an initial meeting. And the first thing that almost always happens, people come in with this 1,000-yard stare because Medicaid is complicated. They've heard rumors, they've heard different things from different people, most of it's wrong. And one reason is because Medicaid is confusing. The U.S. Supreme Court, in the case cited on this slide, said that Medicaid is a Byzantine structure. It's almost unintelligible to the uninitiated. So one of the first things we have to get past is all the confusion created by myths. And you cannot take your legal advice from the neighbor lady across the street. You cannot take your legal advice from non-lawyers because they will not know the rules. When we are trying to work with people initially in my conference room, we've got a whiteboard, and frequently we're going to put up the income and the resources and just outline everything that someone has, what we're dealing with. In Medicaid land, the term assets is defined to include both income and resources, and then resources are those things of value that you had when the month began, and income is what you receive during a month. The Medicaid rules are not the same as the tax rules, which is one reason why things get confusing. People might presume that taxable income and Medicaid income have the same meaning. They do not, and they don't understand why certain things are exempt, why other things are countable, and that is one of the many things that we try to cover with people when they come in. Now, most of the exempt resources are exempt for policy reasons. The home, which we look to the Georgia Medicaid manual to see what it says about the home, is exempt because if you got better, we would want you to be able to go back home. And if we made you sell your home because you were seeking Medicaid, then if you got better, you'd have no place to go back to. There are other places to look for Medicaid rules. The federal rules will override the state rules in most cases. Most states are required to have a Medicaid program which is no more restrictive than the SSI program, and for that reason we end up looking at the SSI regulations and the Social Security Program Operation Manual System called the POMS. And if the POMS or the Social Security regulations would be less restrictive than the state Medicaid rules, then the federal POMs and regulations would override the state rules. Now, the contiguous land surrounding the home is also exempt. There is a equity limit for single applicants that does not apply to applicants where there's a community spouse living on the property or a disabled child living on the property. But for example, if you had a home that's surrounded by 50 acres of farmland, it's all exempt unless it exceeds that equity value for a single applicant. And it's considered contiguous even if it is bisected by a road or an easement. So if the utility company came in and put power lines over part of the farm, then it would still be considered contiguous land because the easement does not separate the land for Medicaid purposes. One vehicle is exempt. If you look at the SSI regulations, that vehicle is exempt so long as it is used to transport the applicant. So if there is any argument over whether a vehicle is exempt, so long as it is being used to transport the applicant or the applicant's spouse, then it is exempt. Burials are exempt. If it is a prepaid burial, then it will be subject to a $10,000 limit in Georgia. The rules are different in other states, but in Georgia, it's a $10,000 limit, and that does not apply to burial space items. So long as the burial space item is fully paid for, then it will not count toward the $10,000 limit. So if you are getting a prepaid burial, then you would want to have it itemized so that you could back out the burial space items. Personal property, such as furniture and fixtures at the home, will not count. Medicaid is not going to tell you to have a garage sale to get on Medicaid. In Georgia, the spouse's retirement is exempt, and in Georgia, the applicant's retirement is also exempt as long as it's making actuarially sound distributions, such as required minimum distributions. There are other states where that is not the case. Business income producing property, usually used by the community spouse, is exempt, and that would cover items such as farm equipment if the community spouse is a farmer. It would cover a truck if the community spouse is a truck driver. It would include tools if the community spouse is a mechanic. They're not going to make the community spouse stop working simply to get Medicaid for the sick spouse. And resources that are inside a correctly structured special needs trust will be exempt, as well as income streams inside of a correctly structured special needs trust. This is not an exhaustive list of exempt resources. We're not trying to cover everything that could possibly be covered in this program. We're trying to hit some of the high points. Now here, I'm trying to let you visualize some of the exempt resources: a house, burial, a vehicle. But this is also a good place to note that since the vehicle must be used or should be used to transport the applicant, you got to be careful about what kind of vehicle you buy. It's got to pass the smell test. I'm not sure a two-door Jeep Wrangler passes the smell test on getting a 70-year-old who needs nursing level care to specialist doctor's appointments and things of that sort. So think about what you're buying if you're trying to purchase exempt resources. Now, accountable resources will generally be anything that is not exempt, so long as it has value. If something has no value, then it would not be countable, or if it was countable, it just wouldn't matter. It would become a non-issue because it would not count toward the $2,000 limit. But anything that is not expressly exempt is probably countable. That would include cash, stocks, bonds, CDs, non-home place property, and extra vehicles. And when we say extra vehicles, we mean it doesn't matter if it's rusted out, on blocks, if it has any value at all, Medicaid is going to count it toward the applicant's $2,000 resource limit. In 2023, the resource allowances for an individual applicant, it's $2,000. For a community spouse, the minimum is $29,724. The maximum is $148,620. Georgia allows a community spouse to receive the maximum resource allowance. So in Georgia, a community spouse could keep $148,620 in countable resources plus the applicant's $2,000 in countable resources before resources would be at risk. These numbers change annually. Here I'm giving you a screenshot of the page at medicaid.gov where the current numbers are generally published. Usually they update these numbers in November. The medicaidnumbers.com page, that's a URL that goes to a page at easyelderlaw.com where we try to update the numbers and where we have historical numbers in case you need those. Now on the income side, any of the applicant's income that is not diverted will generally be paid as cost share. That's also known as the patient liability amount before Medicaid pays the balance of healthcare bills. The applicant's income will be subject to an income cap in Georgia and other states that impose an income cap. In those states, a qualified income trust will be needed. That's also known as a Miller trust or a qualifying income trust in some states. It's all the same thing. It's a way to get past the income cap. If you want to read more about those, you can search at Easy Elder Law, search the phrase qualified income trust or Miller trust, and you'll pull up our page discussing that. In 2023, the income cap is $2,742. Again, that's $2,742 in monthly gross income. If the applicant has even 1 penny more than the income cap, then they will need a qualified income trust to become eligible for Medicaid. Now, one of the many myths that we hear people bring in when they're asking questions is this idea that the community spouse's income counts toward the income cap. It does not. The community spouse's income is irrelevant when we're determining whether a qualified income trust is needed. And again, these numbers change annually, and we try to keep them at medicaidnumbers.com. Income diversions. These are the permitted income diversions for an applicant. The applicant is allowed to keep a personal needs allowance. In 2023, Georgia allows them to keep $70 a month for haircuts, snacks, things like that, and don't spend it all in one place. The applicant is also allowed to keep enough of their income to retire medical debt, things where there was a health expense incurred within the 90-day period immediately prior to eligibility. It would also allow the applicant to keep income to cover items that are not covered by Medicaid, such as health insurance premiums. And even after eligibility is achieved, if there are health expenses that are not covered by Medicaid, such as replacement eyeglasses or dentures, then you could submit an IME request, and the incurred medical expenses would reduce the cost share by enough to retire that debt. You can also have a diversion to a low-income spouse, and in 2023 in Georgia, the low-income a spouse is considered to be low income if their monthly income is less than $3,715 per month. I see that the Cameo is covering that number. The slides will be available at easyelderlaw.com on the same page where we're posting this video. And there are also times when other dependents could have income diverted to them, such as if a nursing home resident has a minor child, then income can be diverted to take care of that minor child. What's at risk when we apply for Medicaid? Well, any countable resources over the resource allowance for the individual or for the individual plus the community spouse would be at risk of being spent down prior to achieving eligibility. Any of the applicant's income that is not diverted is at risk. And then there is a deferred risk for exempt resources, usually those that do not go away, like the home and the contiguous land. They would be potentially subject to an estate recovery claim after the death of the applicant. The community spouse's income is not available to pay for the applicant's healthcare expense. If the community spouse is receiving $5,000, $10,000 a month in income, then that income is unavailable to pay for the applicant's healthcare expenses. The problem that you run into is if the community spouse is receiving more income than they spend, they may be accumulating resources because income that is still retained as of the first day of the following month is no longer treated as income. If it is still retained on the first day of the following month, it's now a resource. So if the community spouse is saving money, then we may get to the point where we have a resource eligibility issue. If the community spouse has low income, and here on this slide you can see the number, then some or all of the applicant's income can be diverted to the community spouse. And again, we try to keep the current numbers at medicaidnumbers.com because these numbers are updated annually. Now, one of the problems that we run into, no matter how many times we tell people to pay the applicant's cost share to the nursing home or to the home health provider, invariably, some of them will not listen to us. You can say it 5 or 6 different times in different ways in writing, but routinely we'll run into families that don't pay the cost share, and that is one of the 6 legal reasons for discharging a nursing home legally, is non-payment. And if you don't pay the cost share, then there's going to be a partial non-payment because Medicaid is only going to pay its share of the nursing home bill. So that creates a risk that a discharge will occur. And one reason why this happens is frequently when Medicaid is pending, health care providers don't send invoices, and families assume that if they don't have an invoice that they don't need to pay the bill. That is wrong, and the result can be catastrophic. It can be like a fire burning down your house, neighborhood, or what have you, because families will invariably spend the money on things that they're not allowed to spend money on. The only thing that a nursing home applicant can, or a nursing home Medicaid applicant can spend money on are the things Medicaid says they can spend it on, which would be the permissible diversions I mentioned earlier, the personal needs allowance, incurred medical debt, and a diversion to a low income community spouse. You cannot spend it on other things like utilities or a mortgage payment or a car payment. Those are not allowed under the Medicaid program. Medicaid does not care about your credit rating if you're in a nursing home. All they care about is paying as little as they can pay, which means you have to pay your cost share before they will pay their share of the bill. Now, when we do planning, we're balancing risks, we're minimizing risks. There is no way to eliminate all risk. Um, the One of the initial risks that we're balancing is protecting resources and income from nursing home bills or other bills so that we can get Medicaid to pay the bills versus taxes, or trying to minimize the state recovery risk versus taxes. And in other situations, we might be balancing other risks. For example, if you have a plan that includes a gifting component and you gift money to or property to someone who later files a bankruptcy petition, or who dies, or who gets divorced, um, those resources may be lost, because nursing home expenses are not the only risks out there. There are plenty of other risks, and you are constantly trying to balance risks, and that requires careful attention. And this is a journey. There is no one size fits all way of doing Medicaid planning or trying to get a Medicaid application approved. It's a journey just getting the documentation to prove that someone is eligible. In the long-term care setting, when we're trying to get nursing home Medicaid, home health Medicaid, hospice Medicaid approved, you have to prove that you're eligible. They will not take your word for anything. And so just getting all the documentation might be a journey. And you take it one step at a time, and you keep going until you get it done. Now, there are a lot of different ways to approach planning. And one of the first things I would do is tell people, don't try this at home. Don't try to take advice from the neighbor lady across the street, or from the internet, and assume that you know what you're doing. It takes elder law attorneys years to get to the point where they're comfortable with the Medicaid rules. And you also have to keep in mind that we're not just balancing Medicaid rules, we're balancing property law, contract law, tax law. Uh, we're looking at family law, and a lot of other different areas of law that work together and allow us to achieve a result that's beneficial for our clients. So if you're not an attorney and you're watching this, this is not your cue to go out and try to do this yourself. We would urge you to find a certified elder law attorney and make sure it gets done right. Having said that, Medicaid does not care if you buy or sell resources, as long as your net worth remains the same or increases. So you can sell things even shortly before you go to a nursing home, as long as you get fair market value. If you do not get fair market value, then the transaction might be deemed to be a transfer for less than fair market value. That can either be a gift or a sweetheart deal. And if you have a transfer for less than fair market value, you can end up with a transfer penalty. But if you want to sell your car, if it's worth $5,000 and you get $5,000 for it, there is nothing in the Medicaid rules that will prevent you from selling your car. But you will have converted a exempt vehicle into a countable resource, cash. So let's think about it the other way. What if you did not have a car and you wanted to buy a car? You could take countable cash and buy a car, and you've then converted countable resources into exempt resources. Um, so I would still tell you, don't do this without advice from a certified elder law attorney. Now, if you need to find a certified elder law attorney, you can go to nelf.org. They have a find a lawyer tool, and you can actually click on their map, and it will pull up all of the certified elder law attorneys in a particular state. And then you can pick the one that is closest to you. A certified elder law attorney is someone who has spent a significant amount of time getting ready to help you when you walk through the door. They are not somebody who simply added that to the list of things they do. It's somebody who focuses and specializes in helping you meet your overall needs. A spend down is something that many people talk about. You can spend down paying nursing home bills, or you can spend down paying for other things. The trick is to spend down without wasting money, and that's can be an issue. Or you could spend down in a way that harms you if you don't have good advice. You could actually spend down in a way that puts you in a worse situation. And so, again, we urge you to contact a certified elder law attorney if you are not an attorney and you're trying to get help. Now, things that are easy that you could do if you need updated appliances because your appliances are kaput, you can put new appliances in the home. You can do landscaping around the home, things like that. Or if you're still capable of traveling, you could go see the grandkids before you go to a nursing home, or the community spouse could go see the grandkids before applying for nursing home Medicaid, and that would be an allowable spend down. Planning can also include converting resources to a stream of income. It has to be done right or it won't work. If you use an annuity, there are specific rules that apply to annuities. And one of those is that the state must be a remainder beneficiary on the annuity, which means if you die before it's all paid out, the state may end up getting the money. Promissory note can also be used, but it has to comply with the Medicaid rules. And one of the risks is that the person you loan the money to might walk off with the money and they might leave you in a worse situation. So again, we say don't try this at home. Talk to a certified elder law attorney if you want to consider these options. Divorce is a radical Medicaid planning strategy. It can be used in some situations, but I would strongly urge you to consult with a certified elder law attorney before moving forward. If it's done right, if all of the I's are dotted, the T's are crossed, then all resources awarded to the community spouse should be protected. The cons, first, it might not be done right and it might blow up. There are some states that attack Medicaid divorces. Second, you can create heartbreak unnecessarily by splitting two people up, ending a marriage that might be long-standing, and it might not comport with the couple's spiritual values. If you divorce a couple that we're trying to get Medicaid, then you can lose the income diversion from the sick spouse to the healthy spouse, because we have a rule that allows us to divert income to a low income spouse, but there is no rule allowing us to pay alimony to an ex-spouse. And if the healthy spouse, the community spouse, did not serve in the military, then they could lose access to other benefits like VA aid and attendance if they get divorced. There are many other planning strategies. We're not making any attempt to cover all of them in this program. Here are a few transfers to permitted individuals that are not covered or prohibited by the transfer penalty rules. You can seek separate support for a spouse, which could increase default allowances. In some states, there has been legislation has been passed to try to restrict that. You can pursue a strategy called spousal refusal. Many states will attempt to ignore that rule. You can seek an administrative increase of the resource allowance if the marital income is insufficient to get the community spouse up to the income allowance, but we have to follow the income first rule since the Bloomer decision came out a number of years ago. Caregiver agreements are something to look at, but the rules relating to caregiver agreements are different in every state. So again, contact a certified elder law attorney. Do not try to structure any of these transactions without proper legal advice. And then there's always gift giving, and we say gift last, not first, because if you can find some other acceptable way to do planning that gets you to the point where you would be eligible for Medicaid, then those other ways of getting you to eligibility would not include a transfer of resources penalty. A gift will result in a transfer penalty if the gift was made within 60 months prior to the application. Essentially, it is a math formula, the value of the gift divided by the average monthly cost of nursing home care. The result is the number of months Medicaid will not help. And because of that, any gifting plan must include some kind of thought process and planning on how you're going to pay for care, how care is going to get funded during the penalty period. Again, we're not trying to cover everything that could possibly be covered in this program on Medicaid. We're trying to give you a general overview. This time, there are over 1,300 pages of information on easyeelderlaw.com, and we're trying to add to it on a regular basis. Of course, not all of it covers Medicaid. Many of those pages cover other issues like guardianships, wills, trusts, and things of that sort. But we're trying to add to it all the time. And so what we would urge you to do, again, if you are watching this and if you're trying to figure Medicaid out, contact a certified elder law attorney, find out what you need to bring to the meeting, and then go get advice from somebody who has studied this material and who has some expertise in this subject matter. And with that being said, we wish you the best. We hope you have a blessed day, and take care. And if this was helpful, please refer other people to it. And if Easy Elder Law has been helpful for you, please refer other people to it. Thank you. Bye-bye.